Claremont is a really unique place to practice family law. I practice family law throughout Central Florida, essentially all the way from Hillsborough County all the way to Volusia and Brevard County. In the middle is our bread and butter: Orange County, Lake County, Seminole County, and Osceola County, sometimes Polk, sometimes Hernando, Marion, and all of the rest. But today, my goal is to talk a little bit about the uniqueness of Lake County, the uniqueness of Claremont, and give folks a bit of an insight into the differences that we have encountered between how people approach family law locally in Lake County versus how they might approach family law in other counties. For example, in Lake County, generally in family law, and this may be subject to change at some point, hopefully tomorrow, even though we have no indication that that will occur, Lake County has no official standing order for divorce and paternity cases. What is a standing order? Orange County has one. Hillsborough County has one. Osceola County has one. Seminole County has one. Polk County has one, and so on and so forth. A standing order is a document provided by the court as a backdrop or a default. It says, you may do this with your finances, you may not do this with your finances. You should encourage this kind of time sharing with your minor children. You should pay voluntary child support, for example. Both parties are encouraged to do X, Y, and Z. Both parties are discouraged from doing A, B, and C. It's a few of the do's, the don'ts, the guidelines. Because once you file your case, the court might not have availability to hear any of your issues. Maybe neither side calls their case up for a hearing. But issues happen. Problems abound. What then can you rely on, if not for a standing order, which can lead to a motion for enforcement? If there is no standing order, there's a massive gray zone. No, I am not talking about gray divorce. And just as a quick aside, somebody posted on our YouTube video channel that they thought our video on gray divorce was somehow related to 50 Shades of Grey. And they were very disappointed after they watched our YouTube video on the divorce for people over the age of 50 because it didn't involve any content that was explicit. My apologies, of course, for that. But what we're talking about is Lake County does not have a backdrop of guidelines. Essentially, our petitions contain more as a result. We may have to file more motions and have more hearings than might otherwise be the case in other counties where these standing orders intend to limit litigation, intend to cause the parties to behave in a certain manner to avoid emergency situations. I am not arguing that it actually works. I have no statistical evidence to back it up. I have no evidentiary proof that these standing orders cause people to behave in a manner that is, quote, reasonable or appropriate given the facts of their case. What I do have is a lot of experience that tells me a standing order is a good thing. Lake County does not have a standing order, and most, if not all, of the surrounding counties do. Have I ever recommended the standing order to some folks? Yes, absolutely. I've had conversations and strongly encouraged it. And unfortunately, while we do have policies and procedures to an extent from the judges that are currently installed in Lake County, we do not have anything that provides the parties with even that general guidance for how to behave and how to act in a divorce case. Back to the original premise here. In Lake County, something that I find utterly fascinating is that many people want to meet with their counselors, their divorce and family lawyers, in person. Whereas many folks in Orange County, Seminole County, and surrounding counties generally prefer to have consultations, hearings, and other legal discussions. They generally prefer to have them by Zoom or by phone. That presents a really interesting dichotomy. What it tells me is that folks in Lake County are not only deeply involved in their cases, but they are deeply invested in whom they hire, and they may even have greater flexibility with their work schedules. Whereas many folks in the surrounding counties might have to be at job sites, might have to go to work instead of working from home. And that can lead to this different kind of approach to family law, to the engagement of counsel, and to the relationship among attorney and client. Back to this issue of standing orders. A standing order can be helpful because not everybody knows that payment of voluntary child support can lead to the cancellation of the issue of arrearages. Some people are surprised to find out, of course, 10 months later, 2 years later, you mean I should have been paying child support this whole time, and now I owe thousands of dollars in arrearages? A standing order can help cancel out that entire issue altogether by advising the parties that this is a mandatory thing. Voluntary temporary child support should be paid, and some would argue must be paid. Keeping people on their health insurance. One would think that that is an important thing to prevent utter disaster financially, or an emergency situation in which a spouse or a minor child no longer has health insurance because somebody canceled it thinking that that was a good idea, whether out of good reason, revenge, whatever the case may be. Perhaps if a standing order tells people not to change insurance during the pendency of their case, they might not do it. This has been the best Florida Family Law podcast. I am Jonathan Jacobs of the Jacobs Law Firm. We're so glad that you joined us for this episode. Nothing that I've said here today is legal advice. This is general guidance. This is for referential and entertainment purposes, as of course, our podcast is nothing else if not entertaining, as we break down something that may be incomprehensible and hopefully turn it into regular, everyday language so that you can get a little bit more understanding about how family law works. Thank you so much for joining me.